Ariana M. Perfecto is an attorney at Lagerlof, LLP in Pasadena, California. She focuses on estate planning and trust administration. Ms. Perfecto earned her Juris Doctor from Pepperdine University School of Law. The California Trusts and Estates Quarterly recently published her article entitled The Practitioner's Guide to Preserving the Latino Legacy. Lagerlof LLP is the largest firm in Pasadena with 112 years of experience satisfying clients. Lagerlof LLP is a team of trusted legal advisors on a mission to provide every client with clarity and understanding to succeed in a complex world, grounded in tradition and focused on the future.
Hello, everyone. Welcome to Ethical Issues for Trust, Estate, and Probate Attorneys under the California End-of-Life Option Act. As I'm sure you are aware or can at the very least imagine, the End-of-Life Option Act, also referred to as Death with Dignity or Aid in Dying, faces a great deal of public controversy. And the same is true for similar laws in other states like Oregon and Washington. And this can be a very sensitive topic. I think anything dealing with death, dying, illness, and disability is going to be the subject of a lot of debate because these are very personal issues. Each of us and our loved ones will inevitably be affected. So the point of today's course is not to get into the morality or the politics surrounding the act. Instead, we are going to identify some of the professional ethical implications of the act for us as trust, estate, and probate attorneys. So regardless of how you might feel personally about the act or which side of the aisle you fall on politically, the rules of professional conduct affects us all, including attorneys in other states with similar death with dignity laws in place. So this is our focus for today. How does the Act implicate certain ethical rules of professional responsibility, and how do we best advise and protect our clients? So let's begin. What does the End-of-Life Option Act do, and how does an ethics course like this help you in your practice? The End-of-Life Option Act allows terminally ill adult California residents to request and receive prescription drugs to ingest in order to die. This is very big, consequential legislation. It's no small thing. So as trust and estates attorneys, who regularly advise clients on end-of-life options and care, we need to be familiar with the Act's procedural and eligibility requirements. But there are also a couple of key features of the Act that we need to be aware of and extra sensitive to in order to protect vulnerable people from harm. For example, the Act requires that there be two witnesses to a request to receive aid in dying drugs, and one of those witnesses is allowed to be a beneficiary of the person's estate. And it's not difficult to imagine why this is allowed. Terminally ill patients are usually going through this process with families and their loved ones. And this is also why other people are permitted to be present when the drug is taken, and even why other people can help prepare the drug before it's taken without incurring any kind of civil or criminal liability. Again, this makes sense. We want terminally ill patients to be able to be with family and loved ones when they pass and to have their help in the process. However, these same key features also have the unfortunate and unintended consequence of incentivizing or at the very least facilitating wrongdoing by bad actors who sometimes surround vulnerable people. Therefore, it's very important that we be familiar with the Act's elements and key features to ensure that all of the requirements are met and that relationship and monetary pressures do not unduly influence a client's decision to request aid in dying. This course is divided into two parts. Part 1 gives an overview of the Act's eligibility criteria and procedures, and Part 2 links those criteria to specific rules of professional responsibility. So I'll go over a few fact patterns that will be familiar to you as trust and estates attorneys in order to kind of flesh out the ethical issues that may arise. End of Life Option Act, eligibility criteria and procedures. As I mentioned, California is just one of several jurisdictions with aid in dying legislation in place. Oregon was the first state to allow physicians to assist patients with ending their lives with the Oregon Death with Dignity Act in 1997, followed by Washington in 2008 and Montana in 2009. California became the fourth state with the End of Life Option Act, which is codified in California Health and Safety Code Section 443. A question that I commonly get is whether death with dignity laws are the same thing as euthanasia. Death with dignity laws, like those found in these 9 jurisdictions, is not euthanasia. Euthanasia, which is illegal in the United States, is when someone other than the patient administers the drug to the patient in order to hasten his or her death. And as we will discuss in this course, only the patient, him or herself, under the End of Life Option Act, can administer the drug. So now we will take a closer look at the California Health and Safety Code, Section 443, to determine the requirements. California Health and Safety Code Section 443 allows a qualified individual to obtain aid in dying drugs from a physician. So the code reads, an individual who is an adult with the capacity to make medical decisions and with a terminal disease may make a request to receive a prescription for aid in dying drugs if all of the following conditions are satisfied. 1, the attending physician has given a terminal illness diagnosis. 2, the individual has voluntarily expressed a wish to receive aid in dying drugs. 3, the individual is a resident of California. 4, the individual documents his or her requests according to the Act's requirements, which can be pretty extensive, and we'll review that a little bit later. And 5, the individual has both the physical and mental ability to self-administer the drug. So there's really 2 parts to this code here. The first part of it at the top deals with eligibility. Who is eligible to make a request for aid in dying drugs? And the second deals with the procedural requirements. So once a person is determined to be eligible, what must he or she then do in order to obtain the drugs? And who else might be involved in that process? We are going to focus on a few of the key terms in the code, which are qualified individual, capacity to make medical decisions, terminal disease, and self-administer. So let's start with who is eligible. Who is qualified under the Act to make a request for aid in dying drugs? First, I want you to keep in mind that the person in question may be your client, but he or she could also not be your client. The person in question could be the parent of a client, the adult child of a client, or another person over whom your client has some influence. Many times when we're counseling our clients on their own estate plans, they'll seek our advice on an elderly or sick parent, or simply vent to us about having to care for an elderly or sick parent. And by venting to us, they give us certain facts that could become little flags for us as trust and estates attorneys who are familiar with the Act's requirements. So we'll discuss scenarios like that and corresponding ethical rules in part 2 of this course. But for now, just keep in mind that we may not always be talking about a client when determining who is a qualified individual. So getting back to the slide, a qualified individual is an adult who has the capacity to make medical decisions, is a resident of California, and has satisfied the procedural requirements of the Act. Adult and residency are easy enough to verify. An adult is a person over the age of 18, and residency can be proved with a state-issued ID card or driver's license, a document showing that the person owns or leases property in California, state voter registration, or a recent tax return. Now we will get into the mental capacity of the qualified individual, which, as expected, is not as easy to determine as age and residency. As attorneys, you all know that there are different types of mental capacity. The mental capacity required by the End of Life Option Act is the ability to make medical decisions. The code states that the individual must have the ability to understand the nature and consequences of a healthcare decision and understand the significant benefits, risks, and alternatives. So what this was really asking is, has the person received all the facts about his or her case? Does he or she understand those facts? Is he or she aware of the alternatives to death, such as symptom management, pain care, hospice care? A lot of times people don't realize all the different resources that are available to them. And does he or she understand the outcomes of all of these different options? So this is the information that a person must have in order to make an informed decision. And once that person has made a decision to request aid in dying drugs, the individual must be able to communicate to care providers. And the healthcare provider is ultimately the person who determines if the individual has capacity to make medical decisions, and is also the person who provides the facts that are needed to make an informed decision. And those facts that are needed to make an informed decision are the following: the individual's medical diagnosis and prognosis, the potential risks associated with taking the drug, that death is the probable result of taking the drug, and finally, the possibility that the individual may choose not to obtain the drug, or if already obtained, may change his or her mind later and not ingest the drug. Next, to be a qualified individual, the person must have a terminal disease. Terminal means incurable, irreversible, medically confirmed, and will result in death within 6 months. Finally, the individual must be able to self-administer the aid in dying drug. This means that the person needs to be able to swallow the drug on his or her own without assistance from anyone else. And oftentimes this requirement alone can disqualify, unfortunately, a lot of people from being able to make use of this act, as they need to be able to swallow it on their own. However, as I mentioned earlier, another person can help the qualified individual prepare the drug and may be present when the qualified individual self-administers the drug without incurring civil or criminal liability. So now that we know who is eligible to make a request for aid in dying drugs, what must the eligible person now do in order to actually obtain the drug? What are the steps? The patient or qualified individual must make 2 oral requests to his or her attending physician that are a minimum of 15 days apart, sort of a cooling off period in between, and 1 written request. The request cannot be made on behalf of the patient, including through a power of attorney or advanced healthcare directive, or through any other person like a surrogate, healthcare agent, conservator, or any other third party. Once the requests are made, the attending physician refers the patient to a second physician, the consulting physician. The consulting physician's job is to confirm the attending physician's diagnosis and prognosis. So what is an attending physician? What's a consulting physician? What's the difference? An attending physician is sort of like the primary care physician. This person has primary responsibility for the healthcare of the individual, as well as treatment of the individual's terminal disease. And the consulting physician is the specialist. This is someone who is independent of the attending physician, who's qualified by specialty or experience to make a professional diagnosis and prognosis regarding the individual's terminal disease. So both physicians are responsible for confirming that the patient has the capacity to make medical decisions. So at the very least, this process involves 2 physicians, but there can be more if it's necessary. If the patient, for example, is showing signs of maybe having a mental disorder, either physician shall refer the patient to a medical health specialist for a medical health assessment. The medical health specialist is a psychiatrist or licensed psychologist whose job it is to determine whether this person has medical capacity and also responsible for making sure that the person does not have any sort of mental disorder. If the mental health specialist confirms a mental disorder, then no End of Life Option Act prescription can be written. It's an automatic disqualifier. So once the consulting physician is satisfied that all the Act's requirements are met, he or she provides a compliance form. Once the compliance form is done, the prescription can be written and the drug can be dispensed. However, 48 hours before taking the drug, the patient must sign a final attestation form, confirming that he or she is acting voluntarily in taking the drugs. So those are a lot of steps, a lot of things to remember. Something that I do to help myself remember everything involved is by using the numbers 21 and 22. 21 stands for the two oral requests and the one written, and 22 stands for the two physicians and the two forms. So that's the easy way that I remember all of this, 21, 22. So again, two oral, one written, two doctors, two forms. So let's go back to the written request. The oral requests are very easy to make, and the written request has a lot more requirements. It's much more formal. Health and Safety Code section 443 provides a sample, it's over on the right-hand side, of what the form should look like and what it must contain. By signing the written request, the patient is ensuring that he or she has been made aware of all the facts that we've established are necessary to reach an informed decision. And to recap, those facts are the medical diagnosis and prognosis, the benefits, risks, and alternatives that are available, such as comfort care, hospice care, and pain control, that death is the probable result of taking the drug, that the patient can change his or her mind at any time, and that the request is being made to the attending physician voluntarily. The patient must sign this form in front of two adult witnesses who can attest to the following: that the individual is personally known to them or has provided proof of identity, the individual voluntarily signed the request in their presence, the individual is believed to be of sound mind and not under duress, fraud, or undue influence, and finally, that the individual is not someone for whom either of them is the attending physician, consulting physician, or mental health specialist. So who can be a witness? The patient's attending and consulting physicians cannot be witnesses, and neither can the mental health specialist. But for the End of Life Option Act, what's more interesting than who can't be a witness is who can be. One of the two witnesses can be related to the patient by blood, marriage, registered domestic partnership or adoption, or entitled to a portion of the individual's estate upon death, or someone who owns, operates, or is employed at the healthcare facility where the individual is receiving medical treatment or resides. So even though the physicians who are formally a part of this process cannot serve as witnesses, the Act does not prevent a nurse or some other person working in the treatment center from serving. And as I discussed earlier, the practical reasons for allowing these essentially interested witnesses are pretty clear. We want patients, families, and friends to be able to go through this process with them. And also, given the situation and how severe it may be, we might need someone who's working at the healthcare facility to serve as a witness. But as I also said before, these rules may create potentially dangerous situations, so we as the attorneys need to be alert to this. So what does this process look like from the physician's perspective? From the physician's perspective, the attending physician must receive all three requests from the patient. So both oral requests and the written request have to first pass through the attending physician. Both the attending and the consulting physicians must complete a statutory checklist, meaning that both must separately ensure that the patient is, one, a qualified individual under the Act, two, that he or she has made an informed decision, and three, has also met all the procedural requirements of the Act. Additionally, within 30 calendar days of writing a prescription, the attending must submit a copy of the written request to the State Department of Public Health, and within 30 calendar days following the patient's death from ingesting the drug, the attending must submit the final attestation form to the State Department of Public Health. So how might the End of Life Option Act come up in the actual drafting of an estate plan? The Health and Safety Code makes it very clear that the act cannot be a condition in a contract, will, or other agreement. So this would seem pretty obvious to us as attorneys, but unfortunately it can be less obvious to some clients that there cannot be an agreement to request or ingest an aid in dying drug. And as trust and estates attorneys, we really do see it all. So it's not that surprising. No surrogates or advanced directives. We touched on this a bit earlier when going over the rule that only the qualified individual and no one else can make a request for aid in dying drugs. A component of an estate plan is healthcare and end-of-life planning. Our clients want to be able to prepare for medical and health emergencies. And as the public becomes more familiar with the End of Life Option Act, we will get the question more and more frequently of whether a request can be made by a loved one or by a qualified individual in an advanced healthcare directive. Many clients ask for themselves, but many will also ask if this is something that they can do for their parents or request for their parents when the time comes. And after this course, you'll be able to tell them that only the qualified individual can make the request. And you'll also be able to guide them on the eligibility and procedural requirements as well. Another very consequential way in which we might see the interaction of the End of Life Option Act and an estate plan is through donative transfers, and particularly through transfers to care custodians. Under Probate Code Section 21380, a provision of an instrument making a donative transfer to any of the following persons is presumed to be the product of fraud or undue influence. 1, to a person who drafted the instrument. 2, a person in a fiduciary relationship with the transferor who transcribed the instrument or caused it to be transcribed. 3, a care custodian of a transferor who is a dependent adult, but only if the instrument was executed during the period in which the care custodian provided services to the transferor or within 90 days before or after that period. So not all care custodians will be subject to this presumption. Only those who provide services during the period that the instrument was made or within 90 days before or after that period. Also, the legal definition of care custodian may not apply to everyone who you might think it does, and we'll discuss that more shortly. Fourth, a care custodian who, while providing services to a dependent adult, enters into a marriage, domestic partnership, or cohabitates with that person, if the transfer occurred or the instrument was executed less than 6 months after the marriage, domestic partnership, or cohabitation. So that's a bit of a long one. What it's really saying is, if a care custodian is caring for a dependent adult and marries that person or moves in with that person, and then receives a transfer or an instrument is executed within 6 months of the marriage or of moving in, that transfer is going to be presumed invalid. 5, a person who is related by blood or affinity to the drafter, fiduciary, or care custodian, a cohabitant of one of these same people, or a partner, shareholder, or employee of a law firm in which the drafter or fiduciary has a partnership share. The presumption created by this statute may be rebutted by proving, by clear and convincing evidence, that the donative transfer was not the product of fraud or undue influence. Care custodian means a person who provides health or social services to a dependent adult. I mentioned a few minutes ago that not every care custodian will fall under the legal definition of a care custodian. Not every caretaker will fall under the legal definition of care custodian. So every care custodian is a caretaker, but not every caretaker is a care custodian, so to speak. So the definition narrows a little bit more. A care custodian does not include a person who provides services without pay if that person also had a personal relationship with the dependent adult. at least 90 days before providing those services, at least 6 months before the dependent adult's death, and before the dependent adult was admitted to hospice care, if the dependent adult was admitted to hospice care. Generally, family members who care for dependent adults without pay, and this happens a lot, will fall into this exception. And it's a good thing, or else a lot of us wouldn't be getting our inheritances. Pay or remuneration here does not include the donative transfer at issue or reimbursement of expenses. And we'll all experience care custodians at some point in our practices. We will meet honest, genuine care custodians, but we will also definitely come across care custodians who are less honest and less genuine, unfortunately. Health and social services means services provided to a dependent adult because of the person's dependent condition, including but not limited to the administration of medicine, medical testing, wound care, assistance with hygiene, companionship, housekeeping, shopping, cooking, and assistance with finances. These are very private, intimate, and often daily activities, so it's really not hard to imagine why close relationships would form between a care custodian and a dependent person. It's completely normal for these people to become very close emotionally, and it's not a bad thing in and of itself. But we need to be able to recognize, however, that the care custodian is in a position of power when the other person is dependent upon them. The dependent person can easily become vulnerable to manipulation and predation. We should be especially aware of this fact when a client starts making or has already made transfers to a care custodian. So who is a dependent adult? A dependent adult is a person who, at the time of executing the instrument at issue under this part, was a person described in either of the following. The person was 65 years of age or older and satisfied one or both of the following criteria. The person was unable to provide properly for his or her personal needs for physical health, food, clothing, or shelter. So in other words, he or she was not able to provide for him or herself physically. And due to one or more deficits in mental functioning, was not able to manage his or her own finances or resist fraud or undue influence. A dependent adult can also be a person who is 18 years or older and satisfied one or both of the same criteria. So again, the person was not able to care for themselves physically or did not have the mental functioning to manage his or her finances or resist fraud or undue influence. The End of Life Option Act can add an additional layer of danger for vulnerable dependent adults. As we just discussed, a dependent person can easily become vulnerable to a care custodian who might essentially try to steal from that person. And the End of Life Option Act makes it possible for a person who's dependent with a care custodian to still make a request for aid in dying drugs to end his or her life, which means also that a dependent person may not only be coerced into making donative transfers, but also can be coerced into ending his or her life. So in addition to ensuring that donative transfers are voluntarily made by the client, we also want to be sure that all of the End of Life Option Act requirements for eligibility are met and that all the procedures are followed. So let's consider the distraught man fact pattern. A distraught middle-aged man sits down in your office and says he just came from his elderly father's home. The care custodian called earlier to say Dad had just passed away in his sleep. The man was confused because the last time he saw his father, just 3 weeks ago, he was in fairly good shape. It was around that time that the doctors confirmed that the father's cancer had come back aggressively. The first doctor had given the father less than 6 months to live, but the father had wanted a second opinion. The man was preparing to visit his father, but then received the call that his father had passed. When the man arrived, he saw an empty bottle of pills on the father's bedside table. The name of the drug doesn't match any of the medications that he knew his father was taking. And when he asked, the care custodian said, not to worry about it, that dad was in a better place. Now he's wondering whether the care custodian did something to push his dad into early death. So he asks you, how can you help? So what questions might we want to ask the son who's in your office? One question is, was dad a dependent adult? The fact pattern provides that dad was elderly, so presumably over the age of 65, but we want to find out whether he was able to provide for himself physically or whether he lacked the mental functioning to manage his own finances or resist fraud or undue influence. Another question is, did dad's estate plan change? And if so, when was the change made? Was it made during the period in which the care custodian was providing services? Because transfers made to the care custodian during the period in which the care custodian provided services or within 90 days before or after will be presumed to be invalid and is also a great indicator of possible wrongdoing. Was dad eligible to use the End of Life Option Act? Dad was terminally ill and an adult, but we need to ask whether he had the mental capacity to make medical decisions and determine that he also was a resident of California, that the request was voluntary, and that he could self-administer the drug. If the son knows, for example, that there's no way the father could have been able to self-administer these drugs, then that would be a giant red flag. Another question would be whether all of the End of Life Option Act procedures were followed. So remember my little tip of 2-1-2-2. 2 oral requests, 1 written request, 2 physicians, and 2 forms. Did dad make all of the requests according to the requirements of the Act? Were the 2 oral requests separated by 15 days? The facts state that only 3 weeks had passed. That's technically enough time for the 15 days to pass in between the 2 oral requests, but 3 weeks is cutting it pretty close overall, given all of the other steps that must follow as well, such as the physician evaluations and determinations of capacity, the written request, and the compliance form and attestation form. We also don't want to immediately vilify the care custodian either. It could very well be that dad simply did not want to tell his son about his plans to receive aid in dying drugs and preferred to go through this process with just his trusted care custodian. But we should still keep our eyes open for other facts like whether dad's estate plan changed in order to make transfers to the care custodian, especially if any transfers were made that were very larger than what the son would receive, or changes to the estate plan which completely cut out the son. The End of Life Option Act creates a safe harbor from liability for the different people who are involved in the process if the rules of the Act are followed. So compliance with the Act is key. For civil and criminal liability, the person who is present when the drug is taken by the qualified patient will not be subject to civil or criminal liability. And the same goes for a person who helps prepare the drug for ingestion by the qualified patient, so long as the person does not actually help with the actual ingestion. Again, terminally ill patients are typically going through this End of Life Option Act process with family and loved ones. And we want family to be there with the patients when they pass. So without this safe harbor, that wouldn't be possible. For the patient who follows the rules of the Act, their death will not be considered a suicide. And this is big because this means that health and other insurances will be protected. You can also tell your clients that even just the request or rescinding of a request for an aid in dying drug is not permitted to affect the sale, procurement, or issuance of life, health, or an annuity policy, and it cannot affect the rate charged. Oftentimes, qualifying individuals feel that they want to obtain aid in dying pills just in case, and may never even use them. They feel better just having them. So this safe harbor allows them to do so without losing their insurance coverages. Also, for a patient who complies, a request that complies with the Act shall not provide the sole basis for the appointment of a guardian or a conservator. And this is great protection for the autonomy of an individual eligible adult. We don't want a request to mean that the person needs to be managed essentially. After all, the person who is eligible will have capacity to make medical decisions and does not suffer from a mental disorder. For the physician, good faith compliance with the Act means that his or her actions will not be considered assisted suicide, homicide, or elder abuse. Clearly, without the safe harbor, prescriptions would never be written. Conversely, failure to abide by the requirements of the End of Life Option Act can expose physicians and others interacting with the patient in this process to criminal and civil liability. The Act makes it a felony to knowingly alter or forge a request for an aid in dying drug to end an individual's life without his or her authorization, or to conceal or destroy a withdrawal or rescission of a request for aid in dying drugs, if done with the intent or effect of causing the individual's death. The Act also makes it a felony to knowingly coerce or exert undue influence on an individual to request or ingest aid in dying drugs for the purpose of ending his or her life, or to destroy a withdrawal or rescission of a request, or to administer an aid in dying drug to an individual without his or her knowledge or consent. So we'll keep these felonies in mind as we go through the fact patterns and the rules of professional responsibility that may be implicated. End of Life Option Act and California Rules of Professional Responsibility. Now we move into part 2 of this course. Part 1 gave us an overview of the Act's eligibility criteria and procedures. And in part 2, we will link elements of the Act with specific rules of professional responsibility in order to explore the ethical issues that may arise for us as attorneys. Remember that there are 8 other jurisdictions that have similar death with dignity laws in place. Those jurisdictions are Oregon, Washington, Montana, Vermont, Colorado, the District of Columbia, and Hawaii. The attorneys in these jurisdictions are also subject to the same rules of professional conduct that we will be reviewing. So even though the focus today has been on California, the following fact patterns and ethical analyses are by no means limited to just California attorneys. So we begin with California Rule of Professional Conduct 1.3 on diligence. The rule reads, a lawyer shall not intentionally, repeatedly, recklessly, or with gross negligence fail to act with reasonable diligence in representing a client. For purposes of this rule, reasonable diligence shall mean that a lawyer acts with commitment and dedication to the interests of the client and does not neglect or disregard or unduly delay a legal matter entrusted to a lawyer. The big takeaway here for our purposes is that a part of representing our clients with diligence means not unduly delaying the client's legal matter. So let's consider the following fact pattern. A longtime client suddenly asks you to change the estate distribution amounts to her 2 adult children. The client says that she recently received some medical bad news. She has cancer and her doctor thinks she has less than 6 months to live. Her son wants her to put her affairs in order, while her daughter wants her to enroll in an experimental treatment study. The client admits to feeling sad at this turn of events and worries about becoming a physical and financial burden to her children. Tensions are at an all-time high between the son and daughter, especially after the son suggested that the client get aid in dying pills just in case. The client says the daughter is better off financially and the son could really use the money. She asks, how fast can you cut my daughter's share in half and add it to my son's? So I'm sure after hearing this set of facts, you have a lot of questions that you'd like to ask and are probably feeling a little bit concerned for mom. She just received difficult news. Her future probably isn't going to look how she'd hoped. And on top of her own emotions, she has to comfort her kids, who she is also worried about. Mom is vulnerable right now, and when we're vulnerable and scared, it's easy to act hastily. So while we do not want to unduly delay a client's matter, we also need to counsel our clients to take the time that they need. With this scenario and the others that I will be discussing, what I'm really trying to highlight is that the End of Life Option Act can have the unfortunate downside of incentivizing the exercise of undue influence over vulnerable clients for financial gain. No law is perfect, and that is why we as attorneys need to have a heightened sensitivity to undue influence when working with clients who are considering the use of aid in dying drugs. We can't dismiss the warning signs as simply being none of our business or family dynamics. We also don't want to vilify the son right away either. Try to see things from both sides. All we're trying to do here is gather more facts to ensure that the client is protected. So what might we want to ask? Many of these facts, without more background information or without familiarity with the Act's requirements, would seem fairly normal on the surface. For example, it's normal for a client to make changes to her estate plan after receiving medical bad news. It makes things a little bit more real and a little bit more immediate. Unequal distributions among children is also very common. Every child is going to be different from another, and they all have different needs. Some might be well off, like the daughter here in this scenario, and some children may have special needs and just require more care. And as we all have experienced, it's very common for children to disagree on the best course of action to take. But then there's the fact that the son suggested to mom that she obtain aid in dying drugs. We want to find out how much son stands to gain if mom passes sooner rather than later, and whether he's aware of it. Does he know that mom is going to be giving him 75% of the estate now? Who suggested that she do this? Is she doing this voluntarily, or did someone ask her to? So while it's normal for a parent to not want to become a burden on her children, we want to make sure that no one's hinting to her that she'd become a burden. Ask mom why the rush. Walk her through the Act's eligibility criteria and procedures. It's a process that will require some time, so let's get educated about it and learn about other options. After all, the Act requires this knowledge anyway. Also, tell mom that the Act requires that her request be voluntary, and it's a felony to coerce or exert undue influence on an individual to request aid in dying drugs. We don't want son to commit a felony, so let's take a little bit of time. Let's move on to California Rule of Professional Conduct 1.6, confidential information of a client. The rule reads that a lawyer shall not reveal information protected from disclosure unless the client gives informed consent or the lawyer reasonably believes that disclosure is necessary to prevent a criminal act that the lawyer reasonably believes is likely to result in death or substantial bodily harm to an individual. Before revealing any confidential information, the lawyer shall, if reasonable, make a good faith effort to persuade the client to not commit or continue to commit a criminal act, pursue a different course to avoid death or injury, or both, and inform the client at an appropriate time of the lawyer's ability or decision to reveal information. In revealing information, the lawyer's disclosure must be no more than is necessary to prevent the criminal act, given the information known to the lawyer at the time of disclosure. A lawyer who does not reveal information, however, does not violate this rule. Let's go over the fact pattern. Mother is an 85-year-old with a recent terminal cancer diagnosis. Daughter goes with her to request aid in dying pills. Mother's physician decides she is ineligible, so daughter gets a second opinion. This one refers mother to a mental health evaluation. The psychiatrist comes to mother's home, and during the evaluation, mother looks to daughter for answers, and daughter coaches her a few times, even after the psychiatrist asks daughter not to. The psychiatrist saw mother's short-term memory slipping and concluded that mother has early-stage dementia. The psychiatrist says mother does not have the very high level of capacity required to weigh options. The psychiatrist notes that although mother appeared to accept the assessment, daughter became angry. Mother schedules a second evaluation. This time, the psychologist says there is no severe impairment that would limit mother's ability to make a medical decision, but she notes that the daughter had wanted to audio tape the evaluation. The psychologist writes that mother's choices may be influenced by her family's wishes and her daughter may be somewhat coercive. But the psychology writes that mother demonstrates the capacity to weigh differences and articulate her own values. A subsequent evaluation by a medical ethicist reports that mother is both competent and acting on her own. So she gets the pills. Daughter is your client. Assume that she tells you all the previous information. She sounds exhausted and frustrated. When recalling the psychiatrist's refusal to deem mother competent, daughter says, "For me to sit there and witness someone coming in here with all their intellectual acumen and making a judgment call on my mother, it just incensed me." You ask why some of the medical personnel think she's coercing her mother. Daughter responds, "I realize that I sound aggressive and assertive. I've been standing on the roof with a banner, and mother's been behind me with a little flag." This seems like a pretty extreme fact pattern and a little too obvious to be real, right? But it is real. This scenario actually occurred and these quotes are real. So these situations really do come up. And how do we tackle this? First off, has daughter given you enough information in order to make a disclosure to protect mom? In other words, do we reasonably believe that disclosure of client's confidential information is necessary to prevent her from committing a felony that will result in mom's death? Under Health and Safety Code Section 443.17b, if you recall, it is a felony to knowingly coerce or exert undue influence on an individual to request or ingest an aid in dying drug for the purposes of ending his or her life. And on first read, the daughter certainly appears to be behaving coercively towards mom. So at the very least, we definitely have enough information here to probe deeper and determine daughter's intent. So what questions would you like to ask the daughter? What we want to focus on is whether daughter is knowingly coercing mom or exerting undue influence on her. Is it her intention to kind of nudge mom along? Or does she think she's merely being a zealous advocate for mom, albeit overzealous? Why is she pushing so hard for a prescription? She's been coaching, getting additional opinions, being very aggressive. Why does she think mom truly wants this? After all, her memory is slipping. Would the desire for aid in dying drugs be in character for mom or more consistent with mom's behavior when she was healthier? Also, is mom now also planning to make changes to her estate plan? What would daughter stand to gain? Keep in mind here that the client is your daughter, so we don't want to be hurling accusations at her or making her feel attacked. So review the Act's requirements with daughter, and specifically the requirement that this be voluntarily done by mom, as well as the importance of compliance so that she herself is protected from civil and criminal liability. The next rule of professional conduct that could be implicated when working with the End of Life Option Act is Rule 1.7, Conflict of Interest. As an estate, trust, and probate attorney, a potential conflict of interest is most likely to arise with married couples between the two spouses. The rule states that the lawyer shall not, without written consent, represent a client if the representation is directly adverse to another client in the same or separate matter. For most married couples, they will typically agree on what to do with their assets, who to give them to, etc. So their interests are normally not adverse. And attorneys commonly disclose this potential conflict to clients in the engagement agreement so that both are aware that the attorney represents both people and cannot keep secrets from one from the other, for example. But as we will see in the next fact pattern, the interests of a married couple can become directly adverse, especially where one party has ulterior motives. Getting back to the code, the attorney must have informed written consent from each affected client if there is a significant risk that the lawyer's representation of the client will be materially limited by the lawyer's responsibilities or relationships with other clients, a former client, or a third person, or by the lawyer's own interests. And there are other considerations. Even if no significant risk exists, a lawyer shall not represent a client without written disclosure of the relationship to the client where the lawyer has or knows another lawyer in the firm has a legal business, financial, professional, or personal relationship with or responsibility to a party or witness in the same matter, or the lawyer knows or reasonably should know that another party's lawyer is a spouse, parent, child, or sibling of the lawyer, lives with the lawyer, is a client of the lawyer or firm, or has an intimate personal relationship with the lawyer. If the lawyer complies with the requirements of the written informed consent, representation is permitted only if also the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. The representation is not prohibited by law, and that the representation does not involve an assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding. So let's consider this next fact pattern. You have been representing husband and wife in their estate plan for several years. Husband calls you to discuss updating his and his wife's estate plan. He thinks they need to overhaul their plan in light of new circumstances, specifically her terminal illness diagnosis. He says, when I imagine what's awaiting her, medications that will make her sick, potential hair loss and incontinence, I can't help but think she'd be better off dead. We're such active people. We like to vacation in exotic places, explore new foods, meet new people. We were planning an overseas cruise, but now she says she wants to stay home. I canceled her ticket, but not mine. She has siblings who can take care of her while I'm away. Besides, I need to start thinking about what my life is going to be like after she's gone. We need to update our estate plan and make sure each of us has all the necessary powers of attorney in case of an emergency. Oh, and I'd appreciate it if you didn't mention any of this to my wife when she comes. We're not on the same page yet about how to handle her illness. Husband and wife come to see you. Husband dominates the conversation. Wife is very quiet. Husband says, we want to explore all of our options now that we are confronted with my wife's cancer. We're going through the End of Life Option Act process. I'm pretty sure she'll qualify, but I'm worried that if she takes a turn for the worse. The doctors say aggressive treatment could cost a lot, and we've agreed we don't want to mortgage our future when we know this is going to end, when we know how this is going to end. Neither of us wants to suffer. Can you put her wish for aid in dying drugs in her advanced healthcare directive? Can you also give me a power of attorney to get this for her if she can't do it herself? So the question is here, is there an actual conflict in representing husband and wife? There's a conflict in representing husband and wife if the interest of one of them is directly adverse to the other, or if representation of one will materially limit representation of the other. Husband began this process by calling you, the attorney, to discuss wife's terminal illness, as well as his own concerns for his own future. He closed the conversation by asking you to not disclose any of this to his wife. But when the attorney represents both spouses in an estate plan, the attorney can't do this. So unless there has been some other agreement to the contrary, this puts the attorney in a position of conflict. Then both husband and wife come to an in-person meeting where husband is basically, in so many words, stating in front of his wife that he does not want to spend down their estate for her treatment. And even though both spouses are present at this time, husband is proposing that the estate plan be changed in a way that is unfair to wife. And because of the attorney's private conversation with husband, the attorney's knowledge of extra facts, the attorney knows that husband's interests may be directly adverse to the wife. Therefore, separate counsel for each spouse may be best here. Also, wife has been silent. We want to ask her if her silence signifies agreement or whether she's simply being pressured or unduly influenced into silence and agreement. Again, as with the other fact patterns, it's important to run through the eligibility criteria and procedures of the End-of-Life Option Act. Also make sure that they are aware of the civil and criminal liabilities of non-compliance with these rules. Husband also asked whether wife can include a request for aid in dying drugs in her advanced healthcare directive, and whether he can be given power of attorney to get the drugs for her if she can't do it herself. But as we know, the Health and Safety Code section states that a request can be made only and directly by the qualified individual and cannot be made on behalf of the patient, including through a power of attorney or advanced healthcare directive. Additionally, if wife cannot do it herself, then she'd also fail to meet the requirement of self-administration of the drug, which means the affirmative, conscious, and physical act of administering and ingesting the aid in dying drug to bring about death. This husband and wife scenario, just like the previous, is real and the quotes are real. So this should demonstrate to you all of the unfortunate and unintended consequences of the End-of-Life Option Act. And it's why we as trust, estate, and probate attorneys must be extra vigilant when working with clients who are considering the use of aid in dying drugs, and that we be able to explain eligibility and procedures. Hopefully, after listening to this course, you will be able to advise your clients who are considering the use of aid in dying drugs, as well as be aware of the key features of the Act that might make your client vulnerable to manipulation and predation. I appreciate your time and attention. Again, my name is Ariana Perfecto. I am an estate planning and trust administration attorney at Lagerlof in Pasadena. I would love to hear from you with any of your comments or questions, so please feel free to contact me or email me.